Okay, so part 2 of the scope of the exclusionary rule is called proximate cause attenuated doctrine. I just read kind of the introductory case, which was Wong Sun versus U.S., and now the second case, a 1975 case called Brown versus Illinois. Justice Blackmun delivered the opinion of the court. Roger Corpus was murdered, and Corpus's brother told police that Richard Brown was one of Corpus's acquaintances. Police then broke into Brown's apartment and searched it without a warrant. When Brown arrived home during the search, arrested him at gunpoint. They later testified that they made the arrest for the purpose of questioning Brown about the Corpus murder. Detectives took Brown to the police station, placed him in an interrogation room, and read him his Miranda rights. They informed him that they knew of the incident in a pool room when Brown, angry at having been cheated at dice, fired a shot from a revolver into the ceiling. Brown answered, "Oh, you know about that." Police then informed him that a bullet had been obtained from the ceiling of the pool room and had been taken to the crime laboratory to be compared with bullets taken from Corpus's body. Brown responded, "Oh, you know that too." At this point, it was about 8:45 p.m. Police asked Brown if he wanted to talk about the Corpus homicide. Petitioner answered that he did. For the next 20 to 25 minutes, Brown answered questions implicating him in homicide. This question produced a 2-page inculpatory statement, which Brown signed at about 2 a.m. The assistant state attorney arrived, read Brown his Miranda rights, and obtained another incriminatory statement from him. Brown was charged with murder and unsuccessfully moved to suppress both statements. He was convicted and sentenced to imprisonment for not less than 15 years, nor more than 30. On appeal, the Supreme Court of Illinois affirmed that the judgment of the conviction, believing that the Miranda warnings had purged the taint of any earlier Fourth Amendment violation. Petitioner was arrested without probable cause and without a warrant. He was given in full the warnings prescribed by Miranda v. Arizona. Thereafter, while in custody, he made 2 inculpatory statements. The issue is whether evidence of those statements was properly admitted or should have been excluded in petitioner's subsequent trial for murder in state court. Expressed another way, the issue is whether the statements are to be excluded as the fruit of an illegal arrest or were admissible because the giving of Miranda warnings sufficiently attenuated the taint of the arrest. See Wong Sun versus U.S., 1963. In order for the causal chain between the legal arrest and the statements made between subsequent thereto to be broken, Wong Sun requires an act of free will to purge the primary taint. So let's make here a material fact that the petitioner was arrested without probable cause and without a warrant. If Miranda warnings by themselves are held to attenuate, I feel like probable cause might have came from this whole bullet analysis. It didn't have to not come from the bullet analysis, but I guess they just didn't go that far to do that. If Miranda warnings by themselves are held to attenuate the taint of a constitutional arrest, regardless of how wanton and purposeful the Fourth Amendment violation, the effect of the exclusionary rule would be substantially diluted. Arrests made without warrant or probable cause for questioning or investigation would be encouraged by the knowledge that evidence derived therefrom could well be made admissible at trial by the simple expedient of giving Miranda warnings. Any incentive to avoid Fourth Amendment violations would be eviscerated by making the warnings. In effect, a cure-all and the constitutional guarantee against unlawful searches and seizures could be said to be reduced to a form of words. It is entirely possible, of course, that the state here argues that persons arrested legally frequently may decide to confess as an act of free will, unaffected by the initial illegality, but the Miranda warnings alone and per se cannot always make the act sufficiently a product of free will be break for Fourth Amendment purposes the causal connection between the illegality and the confession. They cannot assure in every case that the Fourth Amendment violation has not been unduly exploited. While we therefore reject the per se rule, which Illinois courts appear to have accepted, so they made this per se rule, I guess. We also decline to adopt any alternative per se or but for rule. The petitioner himself professes not to demand so much. The question whether a confession is the product of free will under Wong Sun must be answered on the facts of each case. Yeah, it's fact specific. No single fact is dispositive. The workings of the human mind are too complex and the possibilities of misconduct too diverse to permit protection of the Fourth Amendment to turn on such a talismanic test. The Miranda warnings are an important factor, to be sure, in determining whether the confession is obtained by exploitation of an illegal arrest, but they are not the only factor to be considered. The temporal proximity of the arrest and the confession, the presence of intervening circumstances, and particularly the purpose and flagrancy of the official misconduct are all relevant. And the burden of showing admissibility rests, of course, on the prosecution. On the facts in the instant case, we conclude that the state failed to sustain the burden of showing that the evidence in question was admissible under Wong Sun. Brown's first statement was separated from his illegal arrest by less than 2 hours, and there was no intervening event of significance whatsoever in its essentials. His situation is remarkably like that of James Watoy and Wong Sun. We could hold Brown's first statement admissible only if we overrule Wong Sun. We decline to do so, and the second statement was clearly the result of a fruit of the first. The illegality here, moreover, had a quality of purposefulness. The impropriety of the arrest was obvious. Awareness of the fact was virtually conceded by the two detectives when they repeatedly acknowledged in their testimony that the purpose of their action was for investigation or for questioning. The arrest, both in design and in execution, was investigatory. The detectives embarked on this expedition for evidence in the hope that something might turn up. The manner in which Brown's arrest was effected gives the appearance of having been calculated to cause surprise, fright, and confusion. We emphasize that our holding is a limited one. We decide only that the Illinois courts were in error in assuming that Miranda warnings by themselves under Wong Sun always purge the taint of an illegal arrest. The judgment of the Supreme Court of Illinois is reversed and the case is remanded for further proceedings not inconsistent with this opinion. So that's the conclusion. White concurs. Powell and Rehnquist concur. And so let me see, do I have time to finish this? Let's go for it. Insofar as the court holds, one, that despite Miranda warnings, the 4th and 14th Amendments require the exclusion from evidence of statements obtained as the fruit of an arrest which the arresting officers knew or should have known was without probable cause or unconstitutional, and two, that the statements obtained in this case were in this category. I am in agreement and therefore concur with the judgment. Justice Powell, with whom Justice Rehnquist joins, concurring in part after the White concurrence. The court's rejection in Wong Sun is a but-for test, reaffirmed today. Recognizes that in some circumstances, strict adherence to the Fourth Amendment exclusionary rule imposes greater costs and legitimate demands of law enforcement than can be justified by the rule's deterrent purposes. The notion of the dissipation of the taint attempts to mark the point at which the detrimental consequences of illegal police action becomes so attenuated that the deterrent effect of the exclusionary rule no longer justifies its costs. Application of the Wong-Sun Doctrine will generate fact-specific cases bearing distinct differences as well as similarities, and the questions of attenuated inevitability is largely a matter of degree. The court today identifies the general factors that the trial court must consider in making this determination. I think it appropriate, however, to attempt to articulate the possible relationships of those factors in particular broad categories of cases. All Fourth Amendment violations are, by constitutional definition, unreasonable. There are, however, significant practical differences that distinguish among violations, differences that measurably assist in identifying the kinds of cases in which disqualifying the evidence is likely to serve the deterrent purposes of the exclusionary rule. In my view, the point at which the taint can be said to have dissipated should be related to, in the absence of other controlling circumstances, to the nature of that taint. That police have not succeeded in coercing the accused's confession through willful or negligent misuse of the power of arrest does not willful or negligent misuse of the power of arrest does not remove the fact that they may have tried. The impermissibility of the attempt and the extent to which such attempts can be deterred by the use of the exclusionary rule are of primary relevance in determining whether exclusion is an appropriate remedy. The basic purpose of the rule, briefly stated, is to remove possible motivations for illegal arrests. Given the purpose and notion of voluntariness has practical value in deciding whether the rule should apply to statements removed from the immediate circumstances of the illegal arrest. If the illegal arrest merely provides the occasion of initial contact between the police and the accused, and because of the time or other intervening factors, the accused's eventual statement is the product of its own reflection and free will, application of the exclusionary rule can serve little purpose. The police normally will not make an illegal arrest in the hope of eventually obtaining such a truly volunteered statement. In a similar manner, the role of the Miranda warnings in the Wong-Sun inquiry is indirect, to the extent that they dissipate the psychological pressures of custodial interrogation. Miranda warnings serve to assure that the accused's decision to make a statement has been relatively unaffected by the preceding illegal arrest. Correspondingly, to the extent that the police perceive Miranda warnings to have this equalizing potential, their motivation to abuse the power of arrest is diminished. Bearing these considerations in mind and recognizing that the deterrent value of the Fourth Amendment exclusionary rule is limited to certain kinds of police conduct, the following general categories can be identified. The most readily identifiable are on the extremes: the flagrantly abusive violation of the Fourth Amendment rights on one hand and the technical Fourth Amendment violations on the other. In my view, these extremes call for significantly different judicial responses. I would require the clearest indication of attenuation in cases in which official conduct was flagrantly abusive of Fourth Amendment rights. If, for example, so this is the treatment suggested. If for the first case, if, for example, the factors relied on the police in determining to make the arrest were so lacking in addition of probable causes to render official belief in its existence entirely unreasonable, or if the evidence clearly suggested that the arrest was effectuated as a pretext for collateral objectives, or the physical circumstances of the arrest unnecessarily intrusive on personal privacy, I would consider the equalizing potential of Miranda warnings rarely sufficient to dissipate that taint. In such cases, the deterrent value of the exclusionary rule is more likely to be effective, and the corresponding mandate to preserve judicial integrity most clearly demands that the fruits of official misconduct be denied. I thus would require some demonstrably effective break in the chain of events leading from the illegal arrest to the statement, such as actual consultation with counsel or the accused presentation before a magistrate for a determination of probable cause before the taint can be deemed removed. At the opposite end of the spectrum lie the technical violations, and this is the second treatment of the Fourth Amendment rights. The deterrent purpose of the exclusionary rule necessarily assumes that the police have engaged in willful conduct, or at the very least, negligent conduct has deprived the defendant of some right. In this case, In cases in which this underlying premise is lacking the deterrence rationale, the exclusionary rule does not obtain, and I can see no legitimate justification for depriving the prosecution of reliable and probative evidence. Thus, with the exception of statements given in the immediate circumstances of the illegal arrest, a constraint, I think, is imposed by existing exclusionary rule law. I would not require more than proof that effective Miranda warnings were given and that the ensuing statement was voluntary in the Fifth Amendment sense. Absent aggravating circumstances, I would consider a statement given at the station house after one has been advised of Miranda rights to be sufficiently removed from the immediate circumstances of the illegal arrest to justify the admission at trial. Between these extremes lies a wide range of situations that defy ready categorization, and I will not attempt to embellish on the factors set forth in the court's opinion other than to emphasize that Wong-Sun inquiry always should be conducted with the deterrent purpose of the Fourth Amendment exclusionary rule sharply in focus, and in view of the inevitably fact-specific nature of the inquiry, we must place primary reliance on the learning, good sense, fairness, and courage of justices who make the determination in the first instance. On the facts of record, as I view them, it is possible that the police may have believed reasonably that there was probable cause for petitioner's arrest. The trial court made no determination as to whether probable cause existed for the petitioner's arrest, and therefore would remand for, that's exactly what I thought too, for reconsideration with directions to conduct a further factual inquiries that may be necessary to resolve the admissibility issue. In the footnotes, we see like Knopp versus Texas, Taylor versus Alabama, Dunaway versus New York. In Taylor, majority held the petitioner's confession was the impermissible fruit of his illegal arrest, which then 6 hours. So the Supreme Court has reaffirmed its view that Miranda warnings by themselves are not necessarily sufficient to attenuate the taint of unconstitutional arrest. Okay, so 6 hours, whatever.